The Minister of Justice and Constitutional Affairs, the Honorable NORBERT, whose MP has officially broken his silence regarding the explosive international land dispute reckoning within Uganda. In an unyielding public statement, Minister Mao explicitly denied having any corporate or legal connections to the Atiak sugar factory, dismissing a recent national legal notice targeting him as misguided and labeling the entire push as processing mere nuances value. There's a high-stakes standoff erupted after the Australian-based law firm Equitable Law issued a strict 30-day ultimatum threatening to petition the Australian government to invoke global Magnitsky human rights sanctions against the minister, his family, and corporate affiliates over an unpaid $402,975 land lease contract. The firm had alleged that Mao utilized a dual insider position as both the Pauke clan's former legal counsel and a current board member at Atiak Sugar Factory to facilitate the fraudulent land title and block critical community payments. I am not decision maker here. Mao fires back, responding directly to the serious allegations of conflict of interest and human rights violation. Minister Mao fundamentally rejected the core premise of the complaint. He clarified that he holds no executive, legal, or administrative sway over the sugar company's financial operations or land holdings. I'm not a director of Atiak Sugar, and I've never been a member of the board of Atiak Sugar. Minister Mao stated definitely, I'm not a lawyer for Atiak Sugar. I'm not in any decision-making position in matters of Atiak Sugar. Now, expressing absolute confidence that international authorities would see through the strategy, the Justice Minister noted that he fully expects the international complaint to be thrown out upon a cursory review. I'm sure they will investigate and dismiss the request because all it has is a nuanced value. Mao had it. He did not live without a geopolitical counterattack. Look at your own backyard rather than restricting his defense to democratic legalities. Minister Mao launched a sharp geopolitical counter-offensive against the Adelaide-based law firm spearheading the international sanctions petition. He challenged the Western lawyers to redirect their human rights advocacy toward historical injustices within their own boards before intervening in Ugandan land management. If that law firm is serious about human rights, they should start by fighting for the rights of Australian native Aboriginal people who suffered dispossession of their native land, genocide, and crimes against humanity. Mao fired back. So he went on to talk about the proper legal forum. That's the Ugandan courts. So addressing the allegations of personal liability regarding the Pauke clan's missing $402,975 lease compensation, the Justice Minister maintained that international sanction bodies are entirely the wrong avenue for contract resolution. He emphasized that if the local claimants believe they have suffered a genuine civil or legal wrong, they must utilize the established sovereign judicial infrastructure within Uganda rather than running to foreign jurisdictions. If I am liable in a way for the wrongs the complainants allegedly suffered, the Ugandan courts are a good first step, the minister concluded. With the 30-day countdown served by International Council currently ticking down, Minister Mao's aggressive defense draws a clear battle line. By dismissing the Magnitsky threat and shifting the burden of proof back to local courts, the Justice Minister has challenged the international legal team to either prove their allegations in a domestic court of law or proceed with what he deems a birthless foreign petition. All eyes now from to Equitable Law and the Pauke clan representative to see if they will call the minister's bluff or file a local lawsuit.